Hello folks, welcome once again to Radical Freedom. I'm your host Kurt Waldrop. Today we're going to take a look at the Supreme Court again, specifically asking the questions, should Supreme Court justices have term limits? We'll take a look at a few of the poster children for those term limits. For example, Ruth Bader Ginsburg. Don't know why I have problems with that. Here she is looking like the star of Weekend at Bernie's. It makes me wonder if the other justices put wires on her and move her around like a puppet or something, just out of old time's sake, I suppose. Either that or maybe they just don't want Trump to appoint another conservative justice. Here she is sleeping during Obama's State of the Union address. CNN stated that, in fact, she had a little bit to drink beforehand. So, well, you know, it's not that she's just really old. It's just that, well, she's a little tipsy. Well, here she is tipsy the year before at the State of the Union address, and here she is tipsy while actually on the court listening to a case. So, which is it, folks? Is she basically an alcoholic who gets drunk all the time, or does she have a little problem staying awake? Or at least awake enough to do her job? That is why we pay her. Let's go back in history a little bit. In 1795, President Washington gave a recess appointment to John Rutledge of South Carolina. He wanted him to serve as the new Chief Justice of the Supreme Court. Well, Washington was apparently unaware that Rutledge was clinically insane, according to the people at the time. In fact, South Carolina Senator Ralph Izard, love that name, said Rutledge was frequently so much deranged as to be in great measure deprived of his senses. Translation in modern language, he needed to be locked up in the upholstered ward. Rutledge tried repeatedly to drown himself in various rivers before finally resigning within a year of his appointment. Apparently, he was a better swimmer than he wished he was. Either that or he wore cork underwear, which apparently was very common at the time. Rutledge's successor, Justice William Cushing, was described also as being much impaired mentally. Apparently, there's a lot of craziness going around in the legal community at that time. Erik Baldwin was confirmed to the Supreme Court in 1830 and was, well, also a nutcase. Baldwin missed, the 1833 term, being hospitalized for what they called at the time incurable lunacy. That's a clinical definition. He did actually, though, remain on the court for 11 more years with his incurable lunacy. Moving right along, Justice Robert C. Greer's problems were widely known among politicians and reporters during the mid-1800s. Historian David Atkinson noted that Greer could scarcely function due to physical and mental decline. In 1869, just days before Greer finally agreed to leave the bench under pressure from his colleagues, Chief Justice Salmon Chase insisted on using the, well, quite frankly, incompetent judge as the decisive vote to strike down a major federal law, the Legal Tender Act. Gee, that pretty much sounds like they're still in there. In 1880, Justice Nathan Clifford was so far over the rainbow that he was described by another justice as a babbling idiot. Well, let's face it, there's a lot of members of Congress that I could describe that way, but anyway, moving right along. That certainly does sound like he would be qualified for Congress, if nothing else. Newspapers called his seat practically vacant at the time due to this illness. But he refused to resign since constitutionally they couldn't do anything about it, and Congress was afraid to even try to impeach him. So he actually died as a justice of the Supreme Court. Now, at the same time of Clifford was also a gentleman named Ward Hunt, who was actually left paralyzed and speechless after an illness. But he also refused to resign because you had to sit as a member of the Supreme Court for 10 years before you could get a pension, and he wasn't there yet. So, by God, he was going to stick around. Congress actually did finally pass a special law allowing him to get his pension just to get him out of there. They couldn't fire him. Besides insanity, there may be other issues that we'd like to take into account. Might make it desirable to be able to remove a justice, Things such as substance abuse, maybe skeletons in the closet. An example of this might be Justice Frank Murphy. He was a former U.S. Attorney General who joined the court in 1940. By the time he was 57, he was addicted to drugs, including the painkiller Demerol. According to his biographers, Sidney Fine, Murphy bought illegal drugs twice a day while he was a member of the Supreme Court. I wonder what his view on legalization issues was. I wonder if he were recused himself if he ever had a case like that. Something to consider. One of the most influential members of the court during this time, by the way, was a gentleman named Justice Hugo Black. He was appointed by Franklin Delano Roosevelt, who's often considered one of our greatest presidents. You know, he's the one who was the president when they rounded up all of Japanese Americans and put them behind barbed wire. What do they call those? Oh yeah, concentration camps. He served from 1937 to 1971, which is where we got a lot of really major decisions, and was an actual member of the Ku Klux Klan. Yeah, that's the guy that I want sitting on civil rights issues. This really isn't the guy I want telling me how I should read the Constitution. There are a number of others. Please do your own research on this. I just wanted you to get an idea of the issues involved. We should also consider such things as judicial malpractice, such as if a justice tries to connect his decision with something that's completely non-constitutional, such as what a sociologist says or the Constitution of another country. Or maybe he takes part of the Constitution and twists it around for their own purpose, such as, the Commerce Clause. I think that person should be impeached by the House, that is, charged. That's all impeached means. Then the Senate actually tries them, and if the Senate finds them guilty, they kick them out. So impeached just means they're charged. It means nothing else. In conclusion to this little series of Supreme Court videos, just want to say that we really need to revamp Article 3 of the Constitution so we can force justices to actually stick to the Constitution. We can all read it. If they come up with something that's not in it, just let Congress vote. And if they say, no, that's not the Constitution, bye-bye. Get them out of there. They don't need to be making the law of the land if they can't read the frigging law of the land. Yeah, I know. I'm sorry. I just get pretty worked up about this. They should be allowed to remove them either for judicial malpractice or, frankly, any reason that prevents them from functioning. Such as being a Klan member or, sleeping through cases. Anyway, that's all for now. I hope you enjoyed my little foray into the twisted minds of at least some in the Supreme Court. Please go below, give me a thumbs up if you would. Subscribe. Please subscribe. I need your subscriptions. Also, if I say anything that you find interesting, go and check out my book, Radical Freedom. Forget the really crazy looking guy on the front. You can easily cover that up with some tape or something. If Amazon says that it's out of print, they're actually incorrect. It's a print-on-demand book. That means you order it, and a fresh copy comes straight out of the oven and into your kitchen. So please give it a buy. Hope you enjoyed the videos. Looking forward to seeing you next time on Radical Freedom. Bye for now.